Former U.S. President Donald Trump is being sued by the Attorney General of New York. Letitia James alleges Trump and his family lied about their real estate company's value in order to secure loans and to get tax breaks.
This investigation revealed that Donald Trump engaged in years of illegal conduct to inflate his net worth, to deceive banks and the people of the great state of New York. Claiming you have money that you do not have does not amount to the art of the deal. It's the art of the steal.
CBC's Magda Gabriselassie is tracking this story from Washington. Magda, good turn of phrase there by the Attorney General. What are some of the details that we heard today about this lawsuit?
Well, we essentially heard her say that Trump and those around him, including his eldest children, were cheating the system and carrying out fraud in several ways over several years. So New York's Attorney General says her investigation revealed that Trump, three of his adult children, and two other executives with his company participated in these actions. She said they made false and misleading financial statements, and that this happened between the years of 2011 and 2021, and it was all for profits. We heard James say that Trump inflated his net worth by billions of dollars, that the value of his assets, including properties in New York, Washington, and his Mar-a-Lago estate in Florida, were also inflated by hundreds of millions of dollars. And we also heard that this was all done in an effort to get better bank loans and other financial benefits. And then on the other hand, she also said that they downplayed the value of assets to pay lower taxes. And she says that this decision to make these calls, to approve all of this, it actually went right to the top to Trump, but she also included his children, Donald Trump Jr., Ivanka, and Eric Trump, as well as two other company executives. Take a listen.
Over the course of our investigation, we found that Mr. Trump, his children, the Trump Organization, created and used more than 200 false and misleading asset valuations on his statement of financial condition over that 10-year period.
So this is a civil lawsuit, but James has forwarded this information to federal agencies and state agencies as well. She believes that there could be potential criminal charges here if any of those agencies decide to go ahead with that.
Now, Magda, has there been any reaction yet from Donald Trump?
Yeah, so Donald Trump says that this lawsuit is a witch hunt. We've heard him say that before, and he laid this out on his social media platform. He also called James a fraud. We do know his lawyers are saying that this lawsuit is meritless, so they're going to fight against this and defend this. Trump has previously denied doing anything wrong, and we do know that he and his children have actually faced James during depositions. Ivanka and Donald Trump Jr., they answered questions, but last month Trump chose to plead the fifth, which is the right not to incriminate himself. So he was asked a bunch of questions and he repeated his position, and we know that his son Eric did the same during his deposition a couple of years ago.
So much, Magda.
Thank you.
That's the CBC's Magda Gabriselassie in Washington.
This is breaking news. Happening right now, New York Attorney General Letitia James making...
He did this with the help of the other defendants, his children, Donald Trump Jr., Ivanka Trump, and Eric Trump, and former Trump Organization CFO Alan Weisselberg and Trump Organization Controller Jeffrey McConney. Mr. Trump and the Trump Organization repeatedly and persistently manipulated the value of assets to induce banks to lend money to the Trump Organization on more favorable terms than would otherwise have been available to the company, to pay lower taxes, to satisfy continuing loan agreements, and to induce insurance companies to provide insurance coverage for higher limits and at lower premiums. This conduct was all in violation of Executive Law, Section 6312, which gives the Attorney General broad and special powers to go after persistent and repeated fraud and illegality. As part of demonstrating illegality under that section of Law 6312, we show that they violated several state criminal laws, including falsifying business records, issuing false financial statements, insurance fraud, and engaging in a conspiracy to commit each of these state law violations. We believe the conduct alleged in this action also violates federal criminal law, including issuing false statements to financial institutions and bank fraud. And we are referring those criminal violations that we've uncovered to the United States Attorney for the Southern District of New York and the Internal Revenue Service. As a result of these violations, we are asking the court to, among other things, permanently bar Mr. Trump, Donald Trump Jr., Ivanka Trump, Eric Trump, from serving as an officer or director in any corporation or similar entity registered and or licensed in New York. To bar Mr. Trump and the Trump Organization from entering into any New York State commercial real estate acquisition or from applying for loans from any financial institution in New York for 5 years. To pay for the financial benefits obtained as a result of the persistent fraudulent practices at an estimated $250 million. And towards the end of my remarks, I will go into the other relief that we are seeking. At the center of the year-long financial scheme were the statements of financial condition that were prepared annually by and for Mr. Trump, specifically from 2011 to 2021. These statements were compiled by the Trump Organization executives and were issued as a compilation report by Mr. Trump's accounting firm. The statements are explicit that the preparation was the responsibility of Mr. Trump. Or starting in 2016, the trustees of his trust, Donald Trump Jr. and Allen Weisselberg, for the sole benefit of Mr. Donald Trump. Each statement was personally certified as accurate by Mr. Trump or by one of his trustees as part of the loan process, with the intent that the information in the statement would be relied upon by banks and insurers. Mr. Trump and Mr. Weisselberg would meet to review and approve the final statement every year. Mr. Trump made known through Allen Weisselberg that he wanted his net worth reflected on the statements to increase, a desire Mr. Weisselberg and others carried out year after year in their fraudulent preparation of the statements. And when asked about these meetings under oath as part of our deposition, both men, Mr. Trump and Mr. Weisselberg, invoked their Fifth Amendment privilege against self-incrimination, and they refused to answer. When asked under oath if he, Mr. Trump, continued to review and approve the statements after becoming President of the United States in 2017, Mr. Trump, again, invoked his Fifth Amendment privilege and refused to answer. Over the course of our investigation, we found that Mr. Trump, his children, the Trump Organization, created and used more than 200 false and misleading asset valuations on his statement of financial condition over that 10-year period. They issued statements that were in clear violation of general accepted principles in the general accounting principles in the United States, despite representing that these statements were prepared in accordance with these principles. Some of the common tactics they used include representing that Mr. Trump had cash on hand that he did not have, ignoring critical restrictions that would significantly impact property values when setting valuations, changing the methodology used to value properties from year to year without reason or notice, and using vastly different methods to value different properties even in the same year, and including tangible items such as brand premiums, the Trump premium, when calculating an asset's value, despite the fact that they ignored the advice of outside professionals. They also ignored the advice and appraisals of outside professionals, despite claiming those individuals